Hey D&D fam, I'm Quick.
And I'm Lee, and you're listening to
Divas and Ducats. So what is a diva? I think divas get a bad rep, but to me, diva is all about the attitude.
As for ducats, it's your finances, your assets, Skrilla, guap, your coin. We're talking all things with the potential to affect your pockets.
And while we're attorneys by trade, we are divas by choice. Divas and Ducats is for edutainment purposes.
Y'all, we are not Series 511 or 703 professionals. This does not create a financial advisor or attorney-client relationship. The views expressed here are solely our opinions and the opinions of our guests.
It's just our opinions, y'all. Okay, divas, let's talk Ducats. What's up, Diva and Ducats family? We are so excited to be here with you. It's the summertime. It is hot up here in the Carolinas. We are glad you are joining in with us today. And before we dive into this topic, I'm the giddy little podcast host right now in Fred, because for y'all that are nosy and listen to us on the airwaves, if y'all head on over to the YouTube page, while you're there, please subscribe. But if y'all head on over to the YouTube page, you will see that my girl has gotten engaged. Flash him a little something. So excited for her, and he did good, honey. Okay, he did good with them ducats.
I'll make sure I play this back, affirm him.
Right. It is beautiful. How are you feeling?
I'm good. I'm gonna get a nice little planner. I'm not gonna get stressed out. We gonna, I'm not a fan of the song, but you won't break my soul.
Right.
So we're gonna be fine.
Right. Mm-hmm. But we are very excited for her. So congratulations. I just wanted to say that on the airwaves.
Thank you.
And what are we going to be getting into today?
Today, we're talking about something a little less exciting because it involves death. Yeah. But we're talking about really protecting your assets and making sure that if you do want certain things to go a certain way, you're putting those things in place. Mm-hmm. So we like to bring subject matter experts in to answer your questions, common questions we have. Make sure if you need them, you can slide in their DMs and reach out and get the best services you need. So without further ado, we let our guests introduce themselves. So just tell us who you are and what you do.
So my name's Robyn Hicks-Guinn. I have a law firm that has brick and mortar offices in Raleigh and Charlotte, but we service clients all over the state of North Carolina. We literally meet them where they are. So if your grandma is in the hospital, we'll come meet her there. If you're seeking business succession planning, we'll come meet you at your office. But what we focus on is business succession planning, estate planning, estate administration, and guardianships. Okay. So what that means is we essentially help individuals, businesses, and families transfer their wealth. Okay.
So that's what the business succession is. It's transferring that business and all that goes with that. Okay. That's often something we don't really think about when we think about estate.
But yeah, that is part of your estate.
Yeah, it is. Cool. I love that.
How did you get into that? Were you just always interested after you took wheels in law school?
No. So growing up, I always thought I was going to be a doctor. And early on in life, I experienced death. My dad passed away when I was 19 from lung cancer. And then shortly after that, my fiance was killed in Iraq in the line of duty. And so I started a nonprofit organization with my fiance's family at the time. And I began advocating for the community, but also learning a lot from both the experiences about estate planning and how it benefits families. And I mean, to be honest, I'm a product of good estate planning, especially from my dad. And so that's really where my heart kind of tugged at me in law school. And I worked in a few other practice areas for a while, but I always found myself going back to that practice area. So that's where I stayed.
I think it's really neat to find your passion.
Mm-hmm.
It's sad that it went through life experiences like that, but like you said, to be the product of it, it really shows the impact. Like that's an experience that you can lend to your clients. Be like, no, because of that, that proper planning and everything happening beforehand, I was able to breathe a little easier, and it's easy for some attorneys to say that when they haven't actually experienced it. So, having that on hand live experience is bar none, as I like to say. So let's get into a little bit of, and we're going to ask, some business succession, because I don't think we had any questions about that. Considering we have businesses, we should have did that. But let's tackle that one actually at the forefront. Like for the business succession, what do y'all like take into consideration when you have that?
Sure. So the first thing we have to look at is what type of business do you have? Is it a small family-owned company? Because we're going to recommend you transfer in a different way, as opposed to maybe it's a husband and wife or a single individual owning a company, and maybe you have a star manager or a star employee that maybe wants to buy your business over time, or provide some sweat equity while they are learning more about your business. And so it really depends on what you're looking to do. But for a family-owned business, I would usually recommend doing that through a trust, and also having some provisions within your operating agreement that allows for that transfer. And then if you're looking at some third party who's not really related to you, then we're looking at some contracts and then also some provisions in your operating agreement.
Okay. And so when there are like partners involved that aren't relatives, then you want to really focus on that in the operating agreement?
Yes, absolutely.
Okay. That's interesting.
Well, we need an agreement.
Yeah, we do.
Well, I mean, I always say partnerships, it's like a marriage.
Yeah.
It is.
We're not opposed to contracts.
Not at all. What you need? What you need from Mason, girl? I get it. So speaking of, quick put me out there. People get married older. I'm not a spring chicken. So people are coming into marriage. A lot of us statistically are older. And so you may have assets. And so, of course, everybody knows prenup. But what are some ways that you could protect your assets if maybe you don't have a prenup, or maybe you do? But what are things that people should think about in terms of estate planning and protecting their assets? So
there are a lot of documents that you can use. It really just depends on what you want to protect. But let's say you have a lot of real estate or even just one house. One thing you can use is a free trader agreement.
Okay.
So that allows you to still have control over that asset, because a lot of times once you're married, a lot of people refinance houses and they don't realize they're transferring their sole their actual interest in that house, and they're making it marital property.
Gotcha.
And so if you have that free trader agreement early on, then that's still allowing you to maintain that interest and do what you want to do with it without passing that interest over to your spouse.
Yeah. Okay.
Another option is a trust. I like trust, but for a myriad of reasons. One, it allows you to maintain some control for revocable living trust, which I recommend for, I would still call you a spring chicken.
Thank you. I appreciate it.
But for my younger clients, for a few reasons, irrevocable trust, once you transfer assets into an irrevocable trust, which is an amazing vehicle within itself that we can talk about later, it's hard to transfer those assets out, because with an irrevocable trust, you are giving those assets to the trust indefinitely. And the only way to undo that is either through the court or every single beneficiary you have designated in that trust has to sign off on it.
Okay.
And sometimes they don't want to.
Right.
Right.
I do that.
Right. But for a revocable living trust, you can put assets in, you can take them out. And so one of the things most people by your age have or do own real property. So usually you cannot borrow against that equity you have in the house if it's inside of a trust. Okay. And so I like the revocable living trust for younger clients. And younger is you're still making plans to buy things in the future, acquire things. So it could still be your grandma,
Yeah.
right? Or your parents. You're able to still shuffle assets around as you need them.
Okay.
But you can also do that through a testamentary will, which is a last will and testament, which has some additional provisions that creates a trust.
Okay.
In the end. But you can also protect assets by making sure that the deed reflects what your intent currently is. So for some people, they know they want their children, right, to have the house in the end. They don't want to share it with the spouse.
Right.
Or maybe they do. And we can talk about what that looks like as well.
Yeah.
But what you would want to do is maybe give that child 1% in the house now, so that no matter what happens, you know that they're going to get some interest later. And we can work on things throughout our estate planning to make sure that your wishes.
Got you. So with the testamentary will, does that mean that the trust is formed upon death? Is that what that is? Or what?
No, so all estate documents are drafted during your lifetime. But the actual trust doesn't become effective until you've passed away.
Got you. Okay, cool. So just following up on that example you provided with, like, say I want it to go to my children, but not my spouse. So if you have a home and you decide, I mean, I want my spouse to still live in this house or still enjoy it, but I want to make sure that, you know, maybe my spouse will get remarried or, you know, I want to make sure that this stays in the family. How do you go about doing, what's the best way to, like, do it from that standpoint?
So either through a trust drafting very specific provisions, or you could create a life estate for your spouse.
Okay.
You do that through a deed. So it's permanent in that you have to file it with the Register of Deeds. But if your spouse is willing, they can always give back that interest.
Okay.
In the real property. But what a life estate does is allow your spouse to stay in the house during their lifetime. With a life estate, you have a measuring life. And so it could maybe be during the life of children that you share.
Okay.
Or so it could be for the lifetime of someone else as well.
Okay.
But when that person passes away, the person who has received that interest, then
it's theirs.
Well, no, actually, it reverts. It goes to your children or whomever you designate, right? Okay. So let's say I have a friend, Melissa, and she already has 2 children. She decides to get married later in life. Let's say at 45 is her second marriage. She loves her husband. She thinks, you know, things are going to go well. He's probably not going to get remarried. She leaves him a life estate.
Okay.
For his lifetime. Then he's able to live in that house. He is able to maintain the house. He's expected to pay taxes on it. He's also expected to pay the mortgage and other things that come along with the house, because it's essentially like you own the house until you don't. But once he passes away, her second husband passes away, she's designated her children as the final beneficiaries. So they would receive.
Okay. Got you.
In the house.
And so with a life estate, for those who have never attended law school, can they sell it, rent it? Like, what can they do with this life estate?
Honestly, they can do anything they want to do. But for most people, they don't find that interest valuable because it's only during that person's lifetime. So would you want to buy a house from someone who, at the point that they die, the interest in the house is going to someone else?
Right. So somebody could be like, actually.
Yeah, it's now my house. Yes. So he could sell it, but it's just he can only give or sell what he has. So he would be giving or selling his life estate.
So through the deed, you can't forbade that kind of stuff. You can't forbid them from selling it, or, you know, in the instance that someone decided they just didn't want to pay the mortgage and it went to foreclosure and they would have lost it, but the child may have been able to pay it, or those kind of things.
Usually, to circumvent circumstances like that, I like to put provisions in the will or the trust. So you can say, as long as they don't do anything to destroy the home, diminish the home's value,
anything against the interest of the property.
Okay, that's good. I like it.
Cool. And so I think we were talking about, like, excuse me, in the instance that that spouse stayed in that home, and let's say, I guess they remarried, and so they're still living, so they still have that life estate in that house. But let's say that, him and the wife decided to move into another property and they decide to rent out that home. Mm-hmm. Can they be required to, I don't know, pay, like the rental proceeds, can they be required to pay those to the child, or?
No, because when you receive that life estate, it's as if you own it, but just for that time, right? Yeah. But just for that time that you're in the house, that you have ownership rights to the house.
Mm-hmm. Okay.
So the children would get what's left over. Mm-hmm. It's called a reversion, or a remainder, rather. Mm-hmm. So they just get what's left over.
Okay.
After that second spouse has used it all up.
Right.
Yeah.
Okay. So I'm just trying to wrap my head around that part about somebody selling their life estate. So let's just use, because I don't like the idea of killing people off. Let's just say mama passed. Mm-hmm. She left daddy a life estate. Daddy decided to sell. As the child, daddy passes 20 years later. As a child, you could go to that owner that's been in there 20 years and say, you got to go.
Yes, because you should have been on notice that he had the life estate. The deed should have been filed at the Register of Deeds. And if it was, then you were put on notice that what you were getting was a life estate.
Mm-hmm. So for because
I'm like, does this happen? Right. It happens. I had a client literally in my office today, where it was her husband received a life estate from his mother, and he passed away. Mm-hmm. And once he passed away, then the house is supposed to go to all of his siblings, and she doesn't have a place to go. And the siblings right now they're being kind to her and not forcing her out. But she trusted that
was going to be there.
She didn't know that that's what was left in the will. Mm-hmm. So she didn't find that out until her husband passed away. And that's not the first time I've seen a life estate where people are just confused on.
Yeah.
So what did the deeds say for these people that need to pay attention to deeds?
Well, if you're the spouse, though, you might not think to...
Mm-hmm. Especially if the documents were drafted before you were married.
Yeah, you're just like, okay, we're in your house.
Mm-hmm.
We're in your mama's house.
Yeah.
Hmm. So what does the deed say?
So it actually wasn't left through a deed, and that's another thing. It was left in a will.
Okay.
And so if you're searching through the Register of Deeds, you may not know that you have to also look at the courthouse to see what was left there. So there are a lot of places that you need to look, especially if there's heirs property and you are aware of it. I would definitely say hire an attorney or get a title search so you know exactly what you own.
But in the instance of it being a will, you really wouldn't know until that person dies, right? I mean, because you're not going to really go to mama-in-law and be like, let me see your will.
Well, but the mother-in-law she's been gone for about 20 years.
Okay.
But the wife just, they were married for 40 years before. Wow. Yeah.
You don't think
you just don't think to do that as life passes by and you're still living in the home and nothing bad has happened. You have good relationships with the family. So it's not uncommon.
Wow. Of course. And I think you spoke to it earlier, but just to clarify, so if you do have a life estate, you still are responsible for like the property tax.
You're still responsible for treating the home as if you own it until you pass away.
Okay. Okay.
And so what rights would the child or whatever the next inherited person would be to put, so if they stop paying taxes or start neglecting the property and they didn't have those additional measures in there that you can't do anything against the interest of the property, do they have any rights?
They do have rights. They can file a suit against the current life estate holder because that individual wasn't supposed to do anything that negatively impacts their remainderment, right? So if you are letting the house get run down, if you're not paying the taxes and now it's in foreclosure, or you're not paying the mortgage, well, then you're affecting my remainder, what I'm supposed to get. So now I'm going to come in and I'm going to protect my interests.
Okay. That's good. So, and talk, because I know you said that you are really in favor of revocable and irrevocable trust. So let's talk about those a little bit versus a will, because I know recently a family member had told me they went to an estate attorney and they said that they didn't necessarily need to do a trust, that they could write their will a certain way. But, and what we're always taught is that if you want to avoid probate, do trust, so what situations can you, I know you were saying you could do something in the will so that it then turns into a trust,
So it's called a testamentary trust. So the trust provisions are embedded in the will. So you still have to go through probate, but after you're done with probate, usually in those types of wills, everything passes over to the trust. Everything transfers to the trust. And then all of the assets are being distributed pursuant to that trust. And so sometimes people might do that to protect the interests of their minor children. Usually when you have really small children, a will, it just might not get it. And let me tell you why. Most people don't realize that if you pass away and you leave minor children and those assets have to pass through probate, then a guardianship has to be opened and a guardian of the estate would be appointed for your children. So let me tell you what that looks like, because most people don't realize that. And I have clients who come to me upset or confused about this process. One, the guardianship estate, it takes 6 weeks within the court system for the matter to be heard. So you may not receive any funds until that particular proceeding has concluded, if you prevail. And also, another attorney called a guardian ad litem will be appointed in that case, and the court will require that the attorney's fees, if there are assets for that minor, are paid from that minor's estate. And so if your child is 5 years old, that attorney is likely going to remain on that case until your child turns 18. So those assets are being diminished every year until your child turns 18. And then also the guardian of the estate can also receive a benefit for serving as the guardian of the estate. And so the reason why I like trust is that you can allow for the trustee to receive a benefit or compensation for their services, or maybe they'll agree to do it for free. Most family members won't take money from a child. And so that's why I like trust, especially if you have minor children. But I like revocable living trust as well because it's private. No one has to see it. If you have a will, everything will be filed with the court. Whether or not you had a life insurance policy, whatever value you had in your bank accounts, the value of your car, your house, everything is available for the public to see. But with a trust, it's private and transfers can be made immediately. So whoever is caring for your children, maybe your mother, or just your loved ones, they're able to receive, some support.
So how are the trusts administered? I mean, because it really sounds like this, documents in the airways. Like with probate, we know there's courts and stuff and people involved. Where is a trust? How do you get that?
It sounds like it's in the cloud.
Yes, it's in the cloud. Like, who's taking care of this?
So a trust, it's a document just like a will, because I know most people have more experience with a will. Is drafted usually by an attorney. I hope by an attorney.
Don't y'all let GPT do
and go online
trust.
and because I've had to. Please don't do it. That's what I'm just saying. Please don't do it.
You don't know enough about it. Like there's too many.
But so the trust is drafted. It should be accompanied by a pour over will. And it should also be accompanied by a certificate of trust. So you should have 3 documents whenever you have a trust.
So y'all didn't know that. Y'all had just said Google to tell you that.
Yeah. No, it won't. It won't. So the certificate of trust that's what is used to prove that who the trustee is.
Mm-hmm.
It will have the trustee's contact information, under what circumstances they can be the trustee, and their responsibilities become active. And that's a document you would usually take to the bank or to your financial institution or the insurance company, whoever needs to know who the trustee is. Whatever the trustee needs to access, whatever assets the trustee needs to access, that's how they would prove that they're the trustee.
Gotcha.
Okay.
And so for that pour over will, what it's used is it's a catch-all to cover whatever you may have left out of your trust or just intentionally decided not to put in your trust for whatever reason. It will allow your executor to have whatever's outside of the trust go through probate and then placed in the trust.
Gotcha.
And then there's the trust, which has the provisions where the trustees are appointed. Your trustee, in your trust, you should also have a special trustee. That individual is someone who could resolve any disputes. So some people like to have co-trustees, so both of their children or both of their siblings. That individual could resolve disputes, but also help your trustees avoid self-dealing. So let's say you have 2 children, you're going to make them the trustees, but they're also the beneficiaries. Right. Well, you may not want them cutting checks to themselves, right? So that special co-trustee can come in. That special trustee can come in and transfer those assets to the individuals who you've appointed.
Okay. Because I was going to ask that. I was like, so what is in there to protect the trustees from being like greedy or doing things they shouldn't do?
So you can be very specific with the language you place in a trust, or some people just want to give their trustees a lot of discretion, which is okay as well. But you can also have someone appointed in your will to provide some oversight. Okay. In the trust that I draft, I also ask for the trustee to provide financial reports. And so it protects the trustee, but it also protects the beneficiary. So they know what's left. They know that their assets are not being squandered. And it provides some transparency, which makes everyone feel comfortable.
Yeah. Okay. So, and this is more so just for people who don't, because honestly, most people who watch our shows are not lawyers. So with this pour over will, does it literally say or does it just look like a regular will?
Both. So at the top, the header it says pour over will. So that lets the court know that all the assets that are left it's going to the trust. But you can have specific provisions in the pour over will if you would like. Most people would prefer that their assets just all be transferred to the trust. But you have some diamond rings you want to leave to your daughter, or you have some stock you might want to leave to your son, and you haven't designated that already with your stockbroker.
Okay.
So does combining a power of attorney with the will make it act like a trust, or do you still have to go to probate? As long as there's a will, you have to go to probate.
Oh, yes. As long as there's a will, you're going through probate. But I want to let everyone know that a power of attorney, it ceases at the time the individual passes away. A lot of people don't know that.
Yeah.
And you can get in a lot of trouble trying to transfer assets once someone has already been deceased. Because the bank may not know.
Yeah.
So they're going to still let you go in and withdraw funds. But I've had to handle some cases where the clerk has issued some sanctions because people are still using their power of attorney.
That person was dead for 6 months.
Yeah, exactly.
6 months.
Yeah.
Wow. Okay.
And the clerk will refer you to criminal court. They have the authority to do that. So,
So I have recently gotten, at least 3 people asking me about transferring their deed into their child's name, like trying to protect it. I don't know, from two of them were newly married. But should you put a child on, let's say they're 18, we're going to take them out of the minor thing because we know you can't do that. Okay. But let's say they're a young, very young adult. Can you transfer, should you, because we know you can, should you transfer your deed to a child?
That is a good question. I think it depends on the maturity of the child. I think it depends on who the child will have around them or surrounding them to support them. And can your child handle the responsibilities that come with the house? Or are they going to forget to cut the grass? So now, the city's coming out every other month issuing citations. Are they going to remember to pay the taxes, pay the mortgage? And some parents provide for payment of that in their trust or in their will. But really, you have to look at your children and decide if they are able to handle those responsibilities.
Mm-hmm.
So in the situations, because I know some people do it for Medicaid purposes and everything, but in the situation where that parent still plans to live in the home, like what are some of the dangers of transferring a deed into your child's name or having them even as a co-owner on that deed while you're still living in the house?
So if you completely transfer, so give your child 100% interest in the house while you are still living in the house, then your child can kick you out of the house. They can sell the house. They can rent it out. You no longer own the house, so you have no control over what happens with the house. And unfortunately, I have seen it often enough where parents have faith in their children, and for whatever reason, their children just do not have the same honor and respect for their parents. But once you give your interest away in the house, it's no longer yours. So if you have the forethought to do that, the best thing to do is place the house in a trust.
Okay.
And you can place it in a revocable living trust. If you're doing it for Medicaid purposes, an irrevocable trust may be the better option, but I usually like to talk with my clients first on a case-by-case basis about which option is best for them. But with a trust, what you're doing is you're maintaining the authority to manage the house during your lifetime, but also live in the house. So it can kind of serve as like what we talked about as a life estate. Yeah. Right. I think that is the best option if you have young children. Now, I've had parents who have been supported by their children for 20 years and they're not sure if they're going to need to use Medicare or not. Well, that's a different story, especially if you are not going to live in the house. Then go ahead and transfer it because Medicare has that 5-year look back period where they're looking at what assets you had to determine what benefits they're going to give you. So oftentimes transferring that property into a trust will offer that protection, specifically in a irrevocable trust. But another option is a ladybird deed.
Okay.
With a ladybird deed, it's similar to a life estate, but it's something that's recognized by Medicare where you're avoiding, now you still have to do it within that 5-year look back period, but Medicaid will not view that transfer as something negative or count it against you. And in the end, then the interest in the house would go to your children if that's who you want to give it to.
So how does that deed differ? Like what is it specific? What makes it a ladybird deed?
Usually there are some provisions in it that allow for, it's called an extended, so it's also called like an extended life estate. And so it's for people who are anticipating staying in the house for long periods of time, looking to still control what's going on with the house. So you're still able to, and you're the measuring life. I know we talked about that. So it's your life that you're measuring, not some other person like we talked about with the life estate. And again, you're able to maintain that control over the house. You're still expected to pay the taxes and all the things. And once you pass away, then your children would own the house. And it's immediate. And it's also equivalent to what attorneys call joint tenants with right of survivorship.
Mm-hmm.
What that looks like is that upon your passing, the other person immediately absorbs your interest in the property. So there's nothing left for Medicare to take because your children have immediately absorbed that interest.
Mm-hmm. That makes sense. So outside of a Medicare situation, because this is a question that I've gotten often, just because when people hear attorney, they think you just do everything. Yeah. They really do. It's like, girl, I have to go look that up. But a situation where, most, not all, but most parents want to give their property to their kids. It's just like, I guess, the natural succession of things. Mm-hmm. So in a situation where they want to do that, like they're living in the house and they want to do that, but they don't, I guess, want a bunch of rigmarole. A lot of the times the question comes up like, well, what did my child have to do about the deed? Like, I'm passing this to this child. It's in the will, but what do I need to do as far as a deed?
Oh, I see. So give me an example, because usually attorneys you don't do the deed until the person's passed away. Because if it's in a will, although the will is drafted during your lifetime, it doesn't become alive or effective until after you've passed away.
Right.
So as an estate administration attorney or probate attorney, even after you've passed away, I'm not allowing for that transfer to happen until a few other things happen with probate. One, we've opened up the estate. Two, the notice of creditors has occurred, so I know that we don't have to sell your house to pay your debt. Three, that you don't have a spouse that can make a claim on the house. A lot of people don't know that there is a statute that allows for, it's called a year's allowance. Your spouse can get up to $60,000 of assets. And then if you have a minor child who is age 22 or less, if you're between the ages of 18 and 22, you have to be in college or have some type of disability. But they receive $5,000. And so that's actually considered the first debt of the estate. Aside from medical debt, funeral expenses, and any other debt that you might have. So sometimes we have to pull the house into the estate to satisfy those debts.
Got you. Yeah, I guess in the context that I'm usually asked, it's just like, I guess assuming, because, older folks, most of them, sometimes, I say most of them, sometimes they tend to be a little more responsible, so they don't really have debts and stuff. And so I guess they just want the child to just be able to have it. Like, they don't want confusion with, well, the name's not on the deed, so what do they need to do? So I think that's the question that comes up. And I know you mentioned, like, there's these trust things, but it sounds like, based on what you said, they just kind of need to go through the process and not really worry so much about this deed. Or am I misunderstood?
So if you're leaving the house in a will, then know that the deed doesn't have to reflect or shouldn't reflect, honestly, because if you've left it in the will, what you're signifying to the court is that you don't intend for a transfer to happen until you've passed away. That's what it means if you leave it in the will.
Okay.
So if you make a deed before you pass away, then you're telling the court, now I want my child to have it right now.
Right. And
then that asset is no longer a part of your estate.
Your estate, because yeah.
So by doing those things through a trust, do you avoid the mandatory $60,000 and potential $5,000? Or
yeah, well, sort of.
It depends.
The spouse won't have access to what's in the trust, but they will have access to anything that flows through probate estate. So the year's allowance is filed with the court, and anything that flows through the court, the spouse and the children are entitled to that.
Just out of curiosity, because I've never gone through probate, but people just seem to be very frustrated with probate. Like, how long is that process?
And that's another answer where I would have to say it depends. But let me just give you a timetable for what it looks like. If we file the first set of letters or application for letters with the court, which if you mail it in, it will take several weeks because the court is backlogged. But if you're able to get an appointment with them, let's say we file it on January 1, now you have to file notice to creditors with a local newspaper, and that notice has to run for 4 consecutive weeks.
Okay.
And creditors have 90 days or 3 months from the first publication to file with the court, right? So now we're at 3 months.
Right.
So then we have to file an inventory with the court. And depending on whether you can get an appointment or you mail that in, then we're a few weeks out from there.
Right.
So we may be at 6 months. But now some people don't have enough money to pay off all the debts. So we have to negotiate with creditors, or family members are not getting along. So we're having to figure out kind of how to divide up some of the property if it's not apparent from the will. And sometimes it takes a while to get all the information you need to know what's actually in the estate.
Right.
And so then you have to transfer everything out of the decedent's name in order to close. And so after you file that inventory, you'll be filing another annual report with the court. Well, some people, I can get their estate opened and closed within 6 months. But that's not typical. One, because we have to rely on the court to get us certain documents and review certain documents. And if you have a case that is not standard, it might take a little longer for the court to review. Or if people file a lawsuit because they are contesting the will, that can take years. Or if you have another complicated case, that can take months or years. So it really just depends on the nature of your case.
Okay. You good?
So much. It's so much.
It's a lot. It's a lot.
So like when you said, I usually have a lot of clients who come to me after they've attempted to do some of the steps and they're just overwhelmed because if you think about it, you're having to do all of this after you've lost someone you love. And so not only are you already just emotionally a wreck, but the process is confusing. So I actually really enjoy being able to help people through that process and just lifting that burden off of them. And I consider that an act of service. So, yeah.
So without getting all into your business, did your dad have a will or a trust?
Both.
He did both. Okay. Why? Why do you, why would that be the recommendation? Because the wills to me just, we know we need them, but it just sounds very frustrating to enforce one. So, what would be the benefits of having a will?
So, if you know you're going to make one-time transfers to a few individuals or you have finite items that you're going to leave, a will is just fine. But when my dad made his estate plans when both my sister and he found out when I was 14 and my sister would have been 10 that he had lung cancer. So he knew that he wasn't going to make it to my sister's 18th birthday. So he wanted to make sure that she was still covered because he had mountains of medical bills. And so he placed some assets in a trust. He and my mom placed assets in a trust to make sure that there would be something for my mom to take care of my sister, to keep our house, or it was their house, but keep our family house. And so that he could still have some control over how we were cared for when he was no longer here. And a will won't let you do that. A will is not a solution for transferring assets long term.
Okay. Makes sense.
It does. And protecting some stuff because, they'll come up after the medical bills.
Yes, they will.
So that's not accessible to the creditors.
The trust?
Yeah, the money that he had put into the trust to take care of y'all, like the hospital couldn't come and say, give me that.
Oh, no. So I like to tell people, a trust is like a box and you can put things in. It is shielded from creditors, if it's drafted correctly. Because a trust is a separate entity, just like most people get an LLC when they start their own business. So that's just like saying, your personal IRS debt is not commingled with your business IRS debt. It's the same thing. So a trust has its own separate EIN number. So just think of it as a business that you started. And most people understand that.
And so you file the attorney, I guess, would file the trust with a bank? Or is it just a document? Like a will, I can have my will at the house. I never have to go to a bank. I never have for it to be an actual document.
Same for the trust. The trust is a document similar to a will, usually a little more extensive.
So you said it has its own EIN number. That would be once you're enforcing it.
Right. But when you open up a probate estate, that also gets an EIN number. Okay. Most people don't know that. But yes, that's how the IRS attaches to
Look at
those estate assets.
Look at them. Okay.
With depending on what type of trust you use, though, you can use your social security number. For example, for a revocable living trust, you can still use your social security number. Okay.
Now, they get paid every April. I don't understand what they need after that.
They want it all.
I'm just saying. You just got paid.
They're going to get theirs.
In April.
And they have the attorneys working. They know how to do all of it. Did you have any other questions?
I don't. This was
a lot of information.
It was.
Be like, I want what she just said with that.
But it was so necessary because I didn't know a lot of this stuff. So I know most people just don't know. And I think, to your point, trust a lot of times seems very abstract and complicated, but it's so beneficial in certain situations. Right. So I'll definitely at some point need to be coming and getting, we can put some things in here. Yeah. So speaking of information, where can the people find you? Where can they contact you if they need your services?
So they can contact me by telephone. The office number is 704-502-5327. They can go on my website, and we have general intake forms that they can access. The website is www.hicksguinnlaw.com. That's HICKSGUINN law.com.
Okay. And we'll be sure to have her information in our show notes so you can just click and go and find what you need to. If you are interested in having some estate planning done or some business succession done through your estate planning. So it was really wonderful having you on. Thank you for coming in the studio with us and being here. This is a lot of information to take in, break down that you can replay over and over. We just want y'all to, you don't want you to work hard all your life and then lose it all because it's not protected right or in the right
be like
buckets.
These celebrities that have so much money and no will. That baffles me every time.
At the very least. Just
get the will.
So. We really, really appreciate you for having us on. So I don't have any tips. I know this was, a longer episode, so there was different information. If I did have a tip, it would definitely be to get your estate planning together and not to wait. We've talked about it before. You don't have to have $1 million in order to have an estate plan. You have some ownership, especially if you have children. If you don't have kids and you're an auntie or an uncle and you have nieces and nephews and you want to direct your properties or your investments, you worked in a job, you got a nice 401k, all that stuff has
anything of value.
You need to have it directed somewhere.
That Jordan collection at Quick Hates.
The IRS
Jordan collection.
Right.
Protect that too. Where you want your Jordans to go?
Absolutely. Protect your assets. You work too hard for them. So, protect them and direct them and tell them where to go.
Yeah. And you can follow us on the things, Divas and Ducats, our website, divasandducats.com, our email, divaadvice@gmail.com, divaadvice@gmail.com. We will see you all soon. Take care of yourselves in the meantime, in between time.
Have a great attitude.
Bye.
Bye.